Welcome to the deep dive. Ever wondered what really stops a new brand from just copying a famous one?
It's definitely not straightforward.
No, it's way more complex. Today, we're plunging into how the Supreme Court guides decisions on trademark infringement, and specifically, interim injunctions.
Right, those temporary court orders.
Yeah.
To stop something potentially infringing while the main case is ongoing.
Exactly. Our mission here is to unpack the criteria courts actually use, how they protect brands and, consumers too.
And what's really key, I think, is that the court stresses flexibility. There aren't these, rigid checklists.
Ah, okay, so it's not a simple formula.
Not at all. Each case turns on its own facts. But they have laid out several interconnected factors that are definitely crucial.
Okay, let's unpack that. You said factors that operate cumulatively.
Yeah, cumulatively. Think of it like several hurdles you have to clear. If you stumble on even one,
Then the court might just say no to that temporary relief.
that's often how it works, yes. So, looking at the big picture, the first thing is a serious question to be tried.
Serious question, meaning?
Meaning the plaintiff, the brand, claiming they've been infringed upon, has to show a real substantial issue, not just a frivolous claim.
Right, it has to be a genuine legal fight worth having. Okay, so first hurdle. A serious issue. What's next?
Next is the likelihood of confusion or deception.
Ah, the confusion part. So courts look at how likely it is that people, consumers, will actually mix the two up.
Exactly. And what's interesting here, like you said, is if that likelihood seems really weak right from the get-go.
They might just decline the injunction then and there.
Potentially, yes. It's a critical early test. It really makes you think about brand trust, doesn't it?
It does, building that reputation brick by brick, and then someone maybe uses a very similar brick.
Precisely. Which leads nicely into the next point, actually. What about the balance of convenience?
Balance of convenience, so weighing the potential harm.
To both parties. The court asks, okay, what happens if we grant this injunction? What happens if we don't?
So if refusing the injunction would, say, really damage the original brand's goodwill or genuinely mislead people,
Then the balance often tips towards granting it. But they also consider the other side. Would stopping this new product, maybe from a small company, cause them huge damage unnecessarily?
that's a crucial distinction. It's not just about the money involved.
Definitely not. Which brings us to irreparable harm.
Right. And this isn't just like lost sales figures, is it?
No, it's often about things that are much harder to put a price tag on. Dilution of the brand's identity, loss of consumer trust, that kind of thing.
Things money can't easily fix.
Exactly. And when that kind of harm seems likely, the courts often say damages aren't enough. Irreparable harm is sort of presumed in those cases.
Presumed. Okay, that makes an injunction more likely then.
Generally, yes. And then there's one more factor, often overlooked but important, public interest.
Public interest. How does that play in it?
Well, especially for things like pharmaceuticals or food, anything touching public health or safety. If there's a real risk of confusion,
Like someone buying the wrong medicine because the packaging looks similar.
exactly that kind of scenario, the court will consider whether stopping the lookalike product is necessary to protect the public. It's that final check.
Okay, so these factors, serious question, confusion, balance of convenience, irreparable harm, public interest, they provide the framework.
They do. And it's interesting, these guiding principles didn't just appear out of thin air. They have roots in legal history.
Oh, like where?
Well, a lot of this thinking was significantly shaped by a big case from the UK, actually. The House of Lords back in 1975. American Cyanamide Co. e Ethicon Ltd.
Right, American Cyanamide. I remember that one. It kind of shifted things towards this more flexible approach, didn't it?
It really did. Moving away from needing to prove a really strong case up front for interim relief toward this multi-factor balancing act.
So let's see this in action. You mentioned a more recent case.
Yes, involving Pernod Ricard. They make spirits, like Blender's Pride and Imperial Blue. They challenged another company for using the name London Pride for a whiskey. Pernod Ricard felt it was too similar, especially Blender's Pride, and used similar styling cues.
Ah, London Pride versus Blender's Pride. You can see why they'd be concerned. Phonetically similar.
On the surface, yes. Many might assume that's pretty clear-cut infringement, right?
You'd think so. But
the court, applying these very principles we've discussed, actually dismissed Pernod Ricard's appeal for an injunction.
really, why?
They looked beyond just the names. They considered the overall visual appearance of the bottles, the packaging, the likely consumers, the whole context.
The whole picture.
Exactly. And concluded that Despite the pride element, London Pride wasn't deceptively similar enough to Blender's Pride to likely confuse the average consumer in the marketplace.
Wow, so the overall impression didn't create that likelihood of confusion even with the name's similarity.
That was the finding. It really underscores that it's a nuanced assessment.
So wrapping this up, what does this deep dive tell us? What's the key takeaway for you, the listener?
Well, I think it shows that trademark law isn't just about spotting direct copies. It's this careful balancing act.
Weighing all these different factors, the claims, seriousness, confusion risk, potential harm, public good.
Exactly. It highlights how courts try to protect established brands and goodwill, but also, allow space for new competitors, provided consumers aren't being actively misled.
It's a fine line.
Yeah.
Which leaves us with a question for you to think about. How do you think courts should strike that balance between protecting valuable brand names and fostering genuine competition and new creativity in the marketplace? Where should that line be drawn?